that the deputy governor received some money, 20,000 from this person, 5,000 from this person, and that's not a case we have had an opportunity to respond to. The gentleman by the name Akai, who against whom the summons are being asked, is being asked to produce the summon, says, I was told by the ward administrator that this happens. Hearsay, first of all. But the second thing is, it is not an issue that we had an opportunity to respond to. And for those reasons, then, we pray that the new evidence introduced be expunged, and we have particular reference to the contents of paragraph 14, paragraph 22, paragraph 23, paragraph 24, and paragraph 25 of the letter from your Directorate of Legal Affairs, which changes the case from what the Speaker said. Now, in that same letter, the Directorate of Legal Affairs also says that please also find a letter from Mr. Ndegwa, which now brings new case. And we are saying, what is the wording of that Rule 20? It says what the Speaker communicated to the other one. When did Ndegwa become...
Counsel, that letter you're referring to?
Yes, ma'am. Yes. Oh, sorry. Actually, that one I can show
contained in a volume?
Yes, may I show you who?
Kindly direct the honorable senators to the volume and to the page.
Yes, it is the County Assembly's bundle, volume 1, page 336, please. 336. Yes, 335. It's the last page, actually. It's practically the last page on the bundle, this bundle here, volume 1. And honorable members, even as you look at that letter, please allow me, I know you might not have this letter which was written to Dr. Monda telling him to come and defend himself, but allow me to just read the first paragraph. It says this: the Speaker of the Senate on 2nd of March 2024 received communication dated 1st March 2024, together with a bundle of documents, stock records, from the Speaker of the County Assembly of Kisii for removal from office of the Deputy Governor of Kisii, Dr. Monda, for impeachment. And then it is listed. Now, when you go to the second page of that document, then it says, sorry, it is in the first page. Item number 1, it says, a letter dated 1st of April. No, sorry, this one you do not, I'm just referring to the letter that was written to the Deputy Governor, telling him to defend himself. And I'm saying in that letter, the writer of that letter from your Department of Legal Affairs introduces things that the Speaker of Kisii had not said anywhere. And amongst them is the letter from Ndegwa. And in that letter of Ndegwa now, we are meeting it in this assembly for the first time. They are saying a fair copy of an affidavit from Dennis. That we never saw. I'm looking at page 335 now.
Yes, what is the issue, Senator Kavindu?
I thought what is taking us through, we should be having copies so that we can follow with him. Because he's taking us through the process so that we can give a ruling. We should have the documents that is taking us through, Mr. Speaker.
Very well, Honorable Senator. Counsel,
yes.
Again, kindly, yes, as you make your opening statement, if you're referring to a document.
Honorable members, I'm referring to page 3.
To the volume and to the page.
Yes, it is volume 1 of the Assembly's document. It is practically the last page. However, unfortunately, I have to cross-reference it to the letter that was written to Dr. Monda, telling him to come and defend himself.
So that letter
is dated
to Dr.
8th of
Monda
March.
is contained in a different volume? Oh, it's not within your bundle of documents?
It is not in any of the bundles, Mr. Speaker, sir.
So can it be circulated? Clerk, that's a document from the Senate, so can copies be done and
yes,
circulate? Yes, according to Council, it emanated from the Council.
Yes, it emanated from the Senate.
It emanated from the Senate.
And it is a letter directly responding to the letter from the County Assembly forwarding the material that was used to impeach the Deputy Governor. And honorable members, all I'm saying is, under the Rule 20, it says this: the case of the County Assembly shall not change in terms of evidence, and shall not change in terms of allegations and will be limited to what the County Assembly Speaker communicated to the Speaker of the Senate. That is the scope of the law. That's Rule 20. Now, in this letter then from the Senate, which is a response notifying us to come and defend ourselves, it immediately changes what the Speaker from the County Assembly had done and introduces new evidence, which begs the question, who intervened and introduced new evidence? And one of them is the letter from Degwa dated, which is the one I'm talking about at page 335. In that, this is what we are being asked. A fair copy of the affidavit of Dennis Misaj. I'm looking at paragraph 3, honorable members. It says, a fair copy of the affidavit of Dennis Misiati, a flash disk containing video clips emanating from public participation, including the one I told you about Masimba. 3, an affidavit of Orenga Yenda saying I was manipulated on a land sale agreement, and 2 crucial protected witnesses. And Mr. Speaker, sir, the preliminary objection we are saying is expunge everything that was not communicated to you by the Speaker of the County Assembly as prescribed by Rule 20. Let the case be limited to the 5 counts plus what Benson says and exclude everything else that was not part of it, which is what I've just referred to, being at those paragraph 14, 22, 23, 24, and 25 of the letter from your Directorate of Legal Affairs. I would just want to close by saying this, that if you constrained us to respond to some of these new things, including Agai, the flash disk and all this, you will be taking away our constitutional rights under Article 47 and Article 50 for fair hearing. We are entitled to at least 3 days notice at the assembly of the case we are supposed to face. We are seeing these things for the first time as we appear before you for purposes of defending ourselves. Mr. Speaker, sir, I want to beg you to please just allow me another 10 minutes, my colleagues, to just say something very briefly in support of my preliminary objection and opening address.
Council,
very kindly, Mr. Speaker, sir.
5 minutes. 5.
Okay.
5.
I will ask Mr. Ochoki first, and then my colleague, and I hope my friend Honorable Gerard Kett won't mind.
Honorable Speaker and honorable members of the Senate, for record, my name is Wilkins Ochoki, part of the team representing the Deputy Governor, Kisii. Honorable Speaker, what is before this Honorable House is not a motion that meets the threshold that will send the DG home. Allow me very respectfully refer to this as nothing more like what we see in the Chinese martial arts movies. It's all fiction, Honorable Speaker. And my senior, Katwa Kigan, has referred you to Standing Order 88 of this Honorable House, which pursuant to that is referred, pursuant to Standing Order 88, Honorable Speaker, Rule 20 of the Rules of Procedure for Hearing and Determination of the Removal of either Governor or Deputy Governor was created, and that rule, as my seniors very well addressed you on, does not allow the County Assembly to bring in new evidence. Because of time limit, Honorable Speaker, allow me just say that what the County Assembly is doing is nothing more than a fishing expedition. The Hansard is clear that upon the Speaker of the County Assembly being asked whether the public participation documents are going to be used in the proceedings of the County Assembly, he was clear that there was nothing at all that was being used. Now you are being told that there are video clips that have been brought, witness statements that were not there. So, Honorable Speaker, I'll respectively just submit that the same ought to be disregarded. There was an application by my learned brothers that you expunge part of the affidavit of the Honorable Deputy Governor. Honorable Speaker, you'll notice that from precedent, this House has allowed governors and deputy governors that did not defend themselves in the county assemblies come here and defend themselves. In any case, the House needs to know the genesis of the problems in Kisii. What exactly is on trial? Because it's not common that the honorable members of the county assembly can wake one morning and determine that a deputy governor that was elected should just go home. So what we want to bring out, Honorable Speaker, is the genesis of the problem. And very briefly, Honorable Speaker, allow me just address preliminary point 2, because my senior Mr. Kigen has addressed 1 within a minute. Honorable Speaker, you'll notice, and the Honorable Deputy Governor agrees that Article 181 of the Constitution, Section 33 of the County Government Act, and Standing Order 60 to 64 of the Kisii County Assembly Standing Orders allow for the impeachment of a governor and a deputy governor. But there are clear timelines that are provided. You will notice, Honorable Speaker, that in the County Assembly of Kisii, and I'll refer the Honorable House to page 5 of the document titled DG. You will notice, Honorable Speaker, that at page 5 of that document of the bundle titled DG, there is a document titled Notice of Motion that is dated the 13th of February 2024. That document was the motion that was brought to the House by the Honorable Wycliffe Siocha. Somehow it mutated, and by the time it was being brought again to the House on 21st of February, we now had another document which starts at page 6 of that document titled DG. So that you'll get, Honorable Speaker, that the Deputy Governor was defending himself on 2 documents dated 2 different dates, and even then, based on the document in page 5 of the document that was received in the County Assembly on 13th of February, Honorable Speaker, the Standing Order 60 to 64 provides that that motion ought to have been heard within 10 days. Whereas we do not want to bring out substantial or procedural issues in this House, but you will consider and look at the timelines within which the County Assembly sat, and you will notice that they sat or determined that motion beyond the 10 days that is provided for in the Senate. And as we will explain, and you will notice that this is beyond the character of the DG. This is all politics. It's all about the hard questions, the tough questions that the DG is asking, that we promise to deliver to the people of Kisii County. We are not delivering. And upon asking those very simple questions, he is now being brought to you, and you are being told, send him home. Thank you very much, Honorable Speaker. Allow us very, very kindly, because I believe I didn't take a lot of time, just bring Honorable Osoro, who's our colleague, to take 2 minutes only, just to finish up and give a final brief on our opening remarks, kindly.
Senator Chirange, what is your intervention?
Mr. Speaker, so that we dispense of this matter, and also for posterity, because traditions and precedent are important, I raise under Article 75 on the conduct of state officers, Mr. Speaker, and I beg to read, and I shall be very quick. A state officer shall behave, whether in public, an official in private life, or in association with other persons, in a manner that avoids any conflict between personal interests and public or official duties, compromising any public or official interest in favor of a personal interest. So, Speaker, I invite you also to look at our standing orders, just in quick succession of Standing Order number 252 on attendance before the National Assembly and reverse. So, Speaker, Mheshimiwa Silvanus Osoro is a member of Parliament of South Mugirango, where the Deputy Governor is facing impeachment allegations. Number 2 is the Majority Chief Whip in the National Assembly, Mr. Speaker. So my concern, in as much as I'm aware of Article 50, but you must interpret the Constitution, both Article 50 and Article 73, Mr. Speaker. I'm aware Deputy Governor Monda is allowed to have a legal representative of his own choice. Mr. Speaker, is it in order for my brother, Mheshimiwa Silvanus Osoro, the MP of South Mugirango, to appear on behalf of Robert Monda, the Deputy Governor? One, because he's a state officer, and two, of conflict of interest that he might send a mixed signals that he is a chief whip of the majority side in the National Assembly. And number three, whether, looking at Standing Order 252, whether the procedure of ensuring him appears before the Senate, not only as an advocate, but also as a member of Parliament. Mr. McHugh, under Article 93, member of Parliament is both a senator and a member of National Assembly. Mr. Speaker, some of us who are learned friends would have wished to appear on behalf of either side. If we allow Honorable Osoro to appear, it means as a member of Parliament, as defined under Article 93 of the Constitution, we can also appear on behalf of either sides that are bringing impeachment motions, Mr. Speaker. And number two, and finally, it is in the public domain, and this will be my conclusion, that the governor of Kisii, Mheshimiwa Simba Arati, and Honorable Silvanus Osoro have had a public altercation. Mr. Speaker, I beg that we should not use Senate as a playground of local politics of what is happening in Kisii, Mr. Speaker. Could it be Senator Osoro, Honorable Osoro, and Simba Governor Arati extending their playful political ground to the Republic of Senate, Mr. Speaker, where we are here only to listen to charges that have the basis of evidence and can stand the test of legal and constitutional and standing orders, Mr. Speaker. So I beg that you rule that Honorable Osoro should relinquish himself from representing Honorable Monda, go back to his house business in the National Assembly, and serve our party, the UDA and Kenya Kwanza majority national. He is the chief whip. We might lose some of the bills at the National Assembly, while Mheshimiwa Osoro is busy representing for personal, financial, gainful, and propelling his professional at the expense of the position that we gave him in the National Assembly, Mr. Speaker. So I beg your ruling, and Senator Osoro should go back to serve the people of South Mugirango and members of National Assembly, Mr. Speaker, and allow this House to proceed. And I know Senior Counsel Katwa Kigen and the other retinue of colleague Learned can do their job well, Mr. Speaker. So I request that on PO, let Mheshimiwa Osoro, there is no problem. They can still continue fighting with Governor Arati in funerals in Kisii, but not in this House. I submit, Mr. Speaker, sir.
Now, yes, Senator Boni.
Thank you.
I hope it's a new matter altogether, not related to what has already been raised.
Mr. Speaker.
Is it something new, Senator Boni?
Yes.
Proceed.
It is new to the extent that he has raised 4 things upon which you should rule. Mr. Speaker, I'm inviting you again to consider ruling on a 5th thing, namely that whereas this is the Senate, but in this chamber this morning and for the next 2 days, Mr. Speaker, we have converted ourselves into a trial chamber. And therefore, Mr. Speaker, any member of Parliament seated in this chamber is seated here as a judge to what's going on. Mr. Speaker, the invitation I'm asking you to make is that if you allow the Honorable Osoro to then sit in this House and do something other than what a member of Parliament is supposed to do in a trial chamber, is it not, Mr. Speaker, tantamount to having a sitting of the High Court, for example, where a judge who would have sat on that matter then jumps and becomes an advocate in the same court, Mr. Speaker. And Mr. Speaker, because we are now going to be setting a precedent, we request you to consider this issue long and hard, because we have some very eminent lawyers in the National Assembly and this Parliament who will then start abusing this to the extent that it will be the disadvantage to the impeachment process. I thank you.
Senator Sifuna.
Thank you, Honorable Senator. First of all, I join...
Is it on the issue of...
no, it's a
Senator
separate
Osoro?
issue.
It's on the issue of Honorable Osoro?
I want to go on record, Mr. Speaker, supporting to the positions taken by the two senators. But I wanted to, with your very great indulgence, Mr. Speaker, because one of the parties has asked us to make a decision on a matter, I was hoping, Mr. Speaker, I could find some clarification on the understanding of the rules of the procedure for this particular process. Mr. Speaker, allow me to find out from the advocate for the Deputy Governor whether in their understanding there is a distinction between evidence and an allegation. Because my understanding of the standing orders, at least as I have read them, is that for as long as there is evidence supporting an allegation that was present in the county assembly. And I'll give a very specific example. If you're being accused of, say, corruption, is it possible that if there are 10 pieces of evidence and 7 are used in the county assembly, is it possible or is it their position that the remaining 3 pieces of evidence supporting the same allegation that was present in the county assembly cannot be presented before the Senate? That is the question I want them to answer for me as I ponder what to do with their objection. And number 2, whether it is their understanding that a public participation is a evidence collection forum. Because in my view, Mr. Speaker, when you go for public participation, you are presenting the case against the Deputy Governor as framed in the county assembly for the public to engage with that case. So that if I'm being accused of corruption, and that is what goes to public participation, is it possible that other people, upon hearing those allegations, might also say, I was also a victim? And then, what in their understanding are we supposed to do with that material? I thank you, Mr. Speaker.
Council.
Thank you, Mr. Speaker, sir, and honorable members. Our emphasis on the Rule 20 is that it prohibits both new evidence and new allegation. Now, on the face of that rule, it's not very clear indeed, and that is an issue I've belabored, whether the intention is that evidence that supports an already existing count is tenable. However, the words used are, assembly is prohibited from introducing new evidence that was not part of the allegations. So that if there is an allegation already in place and evidence was already adduced to support that allegation, you cannot bring new evidence